but they have a pole position because it is by signing the memo that they brought a company into life. The other members didn't bring the company to life, they joined. The subscriber really are the first set of people that are seriously encapsulated and described as body corporate. Now, one of the significance is what we just read, that those subscribers shall be deemed to have agreed to become a member of the company. Because if you didn't deem them to become members, then there is no company. Okay. And that is why the next phrase follows, and on its registration, that is, as soon as you then register the company, then they shall be entered. They shall be entered as the members of, in its register of members. That is, once you register a company, there is a statutory directive to enter the names of subscribers in the company's register of members, because they are deemed to be members. They are deemed to be members. The subscribers, they are deemed to be members. It cannot be otherwise. You can check other legislation, whether, about 3 or 4, particularly on this particular issue. Then you will see how many statutes treat these subscribers. Some are clearer, even than the way we have expressed it. Now, when the law says they are deemed to be members and their names must be entered into, the question is that when you are suing as a member, the company, and they're asking you that you have to prove that you're a member, all you need to do is to do what? If you are not, so now I'm asking you a question. If you are commencing an action and the issue has resurfaced that you would have alleged that you're a member, of the company, how do you prove that you're a member? You can prove that you're a member in one way. But let us go first to subsection 2. Can somebody read us subsection 2 of section 105, please?
Every other person who agrees in writing to become a member of a company and whose name is entered in its register of members is a member of the company.
Very good. Thank you. God bless you. Now you can see that this section 105 is addressing those two categories of members that we saw, the subscriber and those who later agreed to become member in section 42. So the implication is, and of course, the way section 105 has treated it shows that this section also tracks the two categories. The subsection 1 is for the subscriber. The subsection 2 is for those other members that becomes member post incorporation. Now, for the first one, we are told that once you are a member, you are deemed to have agreed to become a member of the company. And as I said, it cannot be otherwise, because if the law says no, then there was no company. These are the same people that brought the company into existence. Okay, so they are the company at the original state. Now, and that is why the law says, the act says, enter their names shall, not may, shall be entered. So which means once the company starts, there are directors and there are secretaries. The first set of names you must enter there is the names of subscribers, because those are the first set of members that give life to the company. It is not it is not the subscriber that will enter their name. They don't have to apply to. Their names must be there. Now, for those who agree, look at the process they have to go through. Every other person who agrees in writing to become members, that is the second set in section 42, and whose name is entered. First of all, every other member who agrees. For the subscriber, the law says they are deemed to have agreed. For this other one, they must agree enter into a contract in writing to become member, and their names must be entered in the register of members. So even when you agree for the second set of members now, contemplated under Section 42, even when you agree that you are a member, you have allotment and stuff like that, the question is that, has your name been entered into the register? If the answer is no, the law doesn't see you as a member until your name is entered. Until your name is entered. But for the subscriber, their name must be entered. Their name must be entered. That's a directive. And they are already deemed to have become a member. So not that they are deemed to have agreed, everything is perfectly done for them. And the reason why the laws will so say is because they are the one that perfected. They are the one that perfected the existence of the company. And therefore, if you are not deeming them, if you are not entering, if entering into the register of members is a sine qua non to becoming member, in their own case, the law says they are deemed to be have agreed and their name must be registered, must be put on the register of members. For the second set of people, they have to have agreed two things they must prove. They have to have agreed and their name must be seen to have been entered in the register of members. So how do you then prove that you are a member if you are a subscriber? Tender the memo. Show them your name. Once they see that, you signed this memo for the purpose of incorporation, yes, then your membership can never be in doubt. The burden to prove membership is discharged because when you have shown that you subscribe, Section 105 takes over in conjunction with Section 42, and proof is assured. But for the second set of people, that is not going to be the case. Okay? I hope you are following these things. So that is why I keep talking about reading Karma. And don't rush when you are reading Karma. If you are rushing it, you will not get so many of these things that we are dealing with. Now, so let's go back to let's go back to Section 42. We have seen the issue of power, that the company that is incorporated now has the power to exercise all the powers that are of functions that are conferred on incorporated company. And what are those powers of incorporated company? So where do we find that? You go now to Section 43. You go on to Section 43. So when you are a body corporate, you are capable of exercising all the powers and performing all functions of an incorporated company, including the power to hold land, to have perpetual succession. But of course, with such, so your liability must be such on the part of members so that they are there to contribute to the assets of the company in the event of being wound up, as is mentioned in the Act. Again, there is a provision that also deals with that particular aspect in terms of the nature of your liability. And then I want you to also go see, let's see. So as we are compiling these things, you take them properly and then you continue to follow it. Let's see. Section, liability of members. Now I want you to see Section 117. The other one we saw Section 105 as regards members. Now go see, judge beside, the issue of liability. Section 117. Section 117. Okay, so everything you need to know, it is there regarding liability. So your obligation to contribute on winding up depends on whether the kind of liability you have, whether your company is limited by shares or is limited by guarantee or it's unlimited, that kind of thing. So that is and there are three of those liability, the liability of limited by share, by guarantee, or it's unlimited. It's a choice at incorporation to determine. And even if you pick one, in terms of liability now, Section 42 is important. Section 117 is important. Section 314 is also important. So when you are looking at membership, you start with 42, you add it with Section 105, add it because you are compounding those things. You are isolating issues and also banding together with them the relevant provisions of CAMA. When you are talking about liability, to have a holistic understanding of the relevant provisions, and so you can inform, because it is only when you're able to read this thing through, assimilate them, that you become confident about company law. It is so easy. It's so interesting. The only problem I see is you. Will you ever have time to read this CAMA? It's not something you just, and fair enough, it's not even a small book, it's a heavy book. So you must like it to carry that kind of burden everywhere. So if you don't want to see it, keep it at home. But the more days you stay away from it, the further karma is to you. So that is just it. Now, the liability, as I said, you look at certain provisions of, first of all, Section 42, second, Section 117, and of course, Section 317. I'm going to be asking you the implications of those sections later, because it is not a joke, it is for a purpose that we are bringing this to you so that you can have a clearer understanding of these things. Now, we move on to, we are leaving liability now, to the powers. The powers, you must add Section 42 with Section 43. Can somebody read up Section 43 for us, please? Now we are doing a forensic analysis of karma so that you want to understand them. And when you talk, yes, you know what you are talking about. You are at peace. You cannot be at peace with yourself talking about karma at this stage.
Okay,
If you are not reading. Now, Edith, you want to say something?
Section 43.
Okay, go ahead.
Sorry, so that was a mistake, but I can help with reading Section 43.
Huh?
I said raising my hand was a mistake, sir.
Raising your hand was a mistake, and you're a member of this class.
That means,
What's a mistake in it?
okay, let me just read Section 43, sir.
Okay.
Okay, Section 43, subsection 1. Except to the extent that the company's memorandum or any enactment otherwise provides, every company shall, for the furtherance of its business or objects, have all the powers of a natural person of full capacity.
Good. And I want every one of you to note what she just read. She said it was a mistake. You don't know, it is only the Spirit of God that has asked you to read this thing. Now that you read it, you cannot forget what you read. If you forget that quickly, then hey. So he reads that for every, except to the extent that the memo or any enactment or that provides, every company, not just one, all of them, every company that is incorporated under Section 42, that's what they are talking about, 42, shall, for the furtherance of its business or objects, shall have all the powers of a natural person of full capacity. So close your eyes a little bit and imagine What are the powers of a natural person of full capacity? Who is that person? It's you. Because all of you in this class, you are a natural person of full capacity. What are those powers that you have? Can you tell me? So I want you guys to be telling me now your powers, physical powers now, not spiritual ones. So, your powers. Yes, what are the powers you have?
I
Well,
have
that
the
is what, okay, go ahead, Mofiola.
I have power to sue someone.
You have the power to sue someone. God bless you. That's the first thing that came to your mind. Are you litigious? It's okay. Yes, you can sue. So if you have the power, which means the company to have that power. Okay? Yes, Boluwatife,
Sir, I can also own assets and sell my assets.
you can buy, you can sell. God bless you. Yes, and I want you not to under explain yourself because what you are giving to the company is what the law says. So please don't understate your powers. Oh, yeah, she says you can buy, she can also own, you know, you can also sell it. She can buy and then therefore own, so she can also sell whatever she buys to somebody else. That is,
I have power
okay, go
to
ahead. No, not you alone. You are so many. I don't want to say everything. Oluwapelumi, yes, and
Okay,
then
so a
I
natural
see.
person can also create or enter into a
No, I
company.
mean, say
Okay.
you.
Okay, me.
Personalize it.
Yes, I
Uh,
can enter into a validly binding contract.
Very good. You can enter into a validly binding contract. Yes. Because if you don't personalize things as you won't be able to understand. You'll be thinking that company resides somewhere and it's different from you. Because the law says, Section 42 says that all you have for the furtherance of, you have all the powers of me, a natural person of full capacity, or is your capacity not full? You have full capacity as a natural person. So what are your powers? That is the easiest way to understand these powers of your company. And that is how we break it down that way. We understand how simple this thing is. And then you can fill in the gaps. Okay? Who else? Hello, Ofolakemi, yes.
Okay, I also have the power to buy and sell land.
Okay, you can buy and sell land. That is true. What else can you do?
So I want to say something else. So I can also appoint people.
Sorry. Have you spoken today?
Yes, sir.
Oluwapelumi, okay. But, this is your first time. Okay, go ahead.
So I was saying that I can appoint people to represent me in
God
cases
bless
where
you.
I'm
God
unable to
bless
pay.
you. God bless you. God bless you. You can appoint somebody to represent you. As a natural person, you can have an agent. Because the Lord said that qui facit per alium facit per se. Whatever you can do by yourself, you can do by another person. So that is true. This is the kind of creativity I want. It's invoking agency, and it is correct because it's one of the powers of a natural person of capacity. And so I take it as right. I can see. Okay, Fawale, I saw your middle, but not you yet. I'm trying to track those who the spirit is touching to speak today because they are very rare. Okay, Fawale,
I can be appointed as a trustee.
you can be appointed as a trustee, so the companies too can exercise that kind of power. Okay, I take it. I take it. Yes, thank you. It is that you are really thinking of natural, but there are still some that I'm waiting for, and it's very strange that a class of almost 300, this particular point that I'm waiting for, none of you have thought it about yourself. That is strange to me. And I don't want to believe that is who you are, that you cannot, there's a particular thing that you are able to do. You have not even mentioned it. The question is, who are you? I'm listening, please. Yes.
Power to reproduce.
Power to reproduce what? Explain. Adetunji,
To have
explain.
subsidiaries. Sorry.
You can have, okay, that is your explanation of reproduction share. You can create. So what you are saying is that since you are a person, sorry, if I'm a person, I can form a company. And because I have that power, since the company is also a person now, confer with a public and with a person, that company can also form another company. That is how you should have put it, so that people don't get it, if I'm mistaken, because you're talking about reproduction. Is formation of companies. A, a natural person of full capacity can form a company, is possible, and of course the company too is empowered to form a subsidiary, because the subsidiary you form would also have corporate personality, just like you do. So I take that with an adjusted explanation that I've given. Okay, so let's still try two people. Peter is here. Mustafa is also here.
Can I speak, bro? Good afternoon, bro.
Good afternoon.
Name is Peter. I can speak and be spoken to. I can communicate. I can think and communicate.
Okay. Yes, I take it. You can speak. Your company too can speak. That is true. But just okay. I will take that. I'll take it. But there are more also refined activity that a natural person can do. Peter, are you the one that your background is talking?
Oh, sorry, sir.
Okay. Now, Mustafa, please go ahead. Mustafa's network is acting up. Now, Badmus Ayomide.
So I think I can also borrow money and also give loans.
God bless you. You can borrow money. God bless you. You can borrow money. You can borrow money. Okay, and so if you can as a natural person, then the company too can borrow money. The company can borrow money, and that is correct. So yes. There's still one I'm waiting for, and up to now,
Sir, can I?
You people are not even
Sir, I want to speak.
Hello,
As a
sir.
person, I can enter into a contract, and a company can do that too.
Yes, they have said that since, but that is
Hello, sir.
Okay.
Yes, Jonathan, Abi.
As a natural person, I am liable for any wrong I've committed, sir.
Liability is not power. For the man that said he can borrow money, I want for the class is a very valid stuff, and I want you to go and see chapter 9, starting from section 191. You would also be more enlightened about that kind of power for the company to borrow. Okay, it was a good. I see that as a very valuable contribution, and I think I can only compliment that initiative with exposure to section 191. If you're not, by the time we are done, you can see the relevance of different sections in what context and stuff like that. Okay. So, Oyeniran, Grace, quickly. I will take 3 more now. After that 3, we can move on.
Power to
Okay.
Okay,
invest.
I can invest, sir.
Wait, I called Oyeniran. Is Oyeniran the one talking now?
Yes, sir. I can invest.
You can invest. God bless you. You can invest. Why are they taking this long? And for the class, I hope you are jotting this thing, because the notes that we are making now, it is your class that is making these notes, so your classmates. If you like, stay there and not listen to us. The class is already, the train has moved. We've been forming notes about these things. My own is to open your eyes, much wider. And then you see, the intelligence from this class, or the resourcefulness of your colleagues in these ones. There is nothing special. It's just to think through these things. We ask, we guide you to think, and because I know you can think, and then answer will start coming. They can borrow, they can invest. There is still something I think you can. Of course, somebody says you can sue and be sued. Okay, yes, that is also true. And many of the things that I said, the only one that was odd was the reproduction thing, but we turn it around to something that is really very, very valuable, because the original intent is really very good. And when you go into group companies, you can see that it's the parent company that is creating a lot of companies that constitute the members of the group, a group company. So, so that is just that. There's still one. I said 2, 3. I have called one as a union. Then Mofiola.
Power to mortgage property.
Yes, you can mortgage. Yes, it's about borrowing. You can mortgage, because if you borrow, you mortgage. Yes, if we mention Yemi Adedeji or Nuruddin Ibrahim. So if you don't get it, I'll mention it so that
Hello,
at
sir.
least you have done enough. Yes,
You called my name, Yemi Adedeji.
go ahead.
Okay, I have the power to hire and fire people to work for me.
God bless you. You can hire and you can also fire. You must love power. This guy want to fire and hire. Yeah, that you are very correct too. Okay, that's good. Thank you. As you want to fire and hire. That is totally correct. Thank you. You can see from the standpoint of you as individuals, as natural person, you have this bouquet of contributions. If we have talked to companies, you would have been limiting your capacity to think widely, notwithstanding the fact that all these things the company can also do. So by populating it this way, you can see how much knowledge that's come to us. Now, Nuruddin.
Good afternoon, sir.
Yeah, go ahead.
So, this one that I want to mention, a natural person is not capable of it, but a company is capable of it. That's
A
perpetual
natural company
succession.
is not doing what? It's not capable of what?
A natural person is not capable of existing perpetually, but a company is capable of perpetual existence.
Okay, yes. That is even not a power. You are just representing this thing. I'm asking you, what can you do? It is what you can do, and of course, the idea of what you can do. Some people, and I don't want to use this just around the one you are doing now, or you are saying now. There is what you call, people do attempt suicide, even when it is against the law, but can the companies, also be suicidal? The answer is yes, because there's what we call voluntary winding up. You can wind up yourself when you are tired as a company, and once you pass a resolution, and people can also force you to, those you are owing, and stuff like that. So in terms of winding up, natural person may commit suicide or attempt suicide. Companies may also, decide on its own to go out of existence, to bring the operations of the company to an end. It is perpetual, but it can be ended. And who are those that can end it? Your creditors can end it. Your members, can also end it that way. Now, let's leave that one alone. The last one I was thinking, and it's not exhaustive, is the fact that as a natural person, don't you give gifts to people? I want to believe you are gift-giving people, yet you cannot think about the capacity to give gifts, to be socially responsible. You visit, some of you, and I know you do it, some of you, and in this particular time, you go to orphanages, you go to motherless people, you go to internally displaced people, you buy a lot of things for them, and stuff like that, just to help, to be socially conscious and helpful. Are you not? A class of over 300, nobody can think about being socially responsible. And if you are, if you can, if you have that kind of power, how come you don't remember that, yes, if you can do it, also companies have the capacity. And companies, you have seen companies, you've worked for some companies, and all you do mostly is to be socially responsible, to give to people. Haven't you come across those companies? You have, but you just forgot because you are still stuck in the company arena. Meanwhile, they are doing it much more frequently than you do. Now, so when you can see how much knowledge Section 42 has brought, okay? How much knowledge of life, of karma, that Section 42 has brought. Now, I will leave that part of it in terms of the implications that here, in that Section 42. There's another part of it, there's another part of it that is not right for me to mention, but which you must know, not in this semester. So by God's grace, we'll be able to explore that, all traceable to Section 42, so that you open your eyes to what this karma, holds for everybody, all of you. So we leave that one. Now, we are looking now at these companies, because we have come back to companies. Remember, I started with you by looking at all the vehicles to do business, and we've exhausted all of them, and I have asked you to look at the pros and cons, ones against the other, okay? And I'm sure that you have worked on those, you tidied them up. All of these provisions I have asked you to read, I'm sure you have also done them. And fair enough, Professor Lawani has come, infused some, concepts, and you have also, and part of this is what we really, went ahead. And I'm sure he cited Solomon and Solomon to you, didn't he? Did he cite Solomon and Solomon? Was it not mentioned to you?
It was, sir.
Yes, it was.
So why are you quiet in the first instance? Did he not tell you to go and read it from the report?
He did, sir.
Okay. I take it that all of you have read it from the report. Is that not it? So, even if there is no answer, you are deemed to have read Solomon and Solomon, like those subscribers that are deemed to have agreed to be members of the company, whose names must be registered. So your names are registered against having read Solomon or Solomon and Solomon. So if you like, don't look at it. You are already deemed to have read it. Now, we look at the company legislation now. what is this is about understanding the nature of the legislation itself, because the size of it makes people shudder. Creates a distance on its own. It's bulky, it's getting heavier and heavier. You are lucky this is the first you are reading company. The one we used to read was very small. Now, under our eyes, or I mean before our eyes, the things start getting bigger and bigger, and it has been like that for so many countries. So, but what exactly, how do you grapple with this kind of legislation? So, company legislation regulates or provides a framework through which private people can can conduct business through the formation of companies. And that when they form it, it provides, framework for them to relate to one another. And so to a large extent, company legislation can be seen as as touching private relationships. Just as, I don't know if I came to your class when you were in year 3 to discuss sale of goods, did I?
Yes, sir.
Did I discuss sale of
Yes,
goods
sir,
with
you
you?
did.
Okay,
Yes, sir.
good. The reason I was doing it, as important as it was then, is for today, this lecture we are doing now. And I'm happy that you still remember it because it's still fresh in your head. Then we were classifying sale of goods into the provision types. We are going to classify for even stronger reasons now for karma. Those things that you learned then, with the exception of people that were playing with it, we are now here. And it will be easier for me to teach this one. We won't even waste much time because you already, you have been exposed to what we are going to discuss, and so it is much easier for you to understand what it is. Now, in a way, you look at company legislation as regulating private interactions. And to the extent that it is focusing on private, by and large, it has to facilitate interaction. By and large, it has to facilitate interaction. And if such legislation is to facilitate transaction, there must be some provision type that constitute the bulk of the legislation. What is that provision type? Is anybody, without me saying it, from the knowledge of yesterday, does anybody remember what kind of provisions would you expect to dominate a legislation that regulates private interaction? Yes, Angela.
I think it would be mandatory kind of legislation.
No. So a legislation that facilitates interaction, to negotiate among people, to make deals, That okay, there's Pelumi too. There's
Sir,
Oluwafulayo.
Sir, it will be enabling.
It has to be enabling. Is that what you want to say, Oluwafulayo?
I want to say default regulation, sir.
Okay. The two of you are very, very correct. It is either one, it has to be enabling, and second, it must have default regulations or provisions. Because remember, every default provision must have an enabling component. A default provision cannot be one if it does not enable first. And again, a default provision cannot be one if it does not have a mandatory content, because the default provision encapsulates all the provision types. And I will explain, in the course of time. But I'm happy that even at the mentioning of this, we all understand what this is. So we've mentioned 3 types. Somebody has mentioned provision that are mandatory, some that are enabling, the others that are also default. Okay. Now, for the mandatory provisions, we can look at company law as relating to preservation of public interest or regulating or protecting the public, because whatever is public, which means there are provisions that are signaling to us to take certain responsibilities for purposes of protecting members of the public who are bound to participate in the corporate system. So to that extent of protecting public interest, company legislation must, to that extent or to an extent, must be mandatory. It has to be mandatory. When you get to the area of accounts, reduction of capital and stuff like that, and then the certification of your, the auditors, of your financial statements by auditors, there are compulsory provisions. When you come to director's duties that you cannot, you are bound, by the duty of loyalty, by good faith, and you cannot take advantage of your company, then there are provisions that are directed at protecting the public, and therefore they are mandatory. So you can see, because there is a need to protect the public in investment, in the use of companies. We have learned the fact that when you go back to your knowledge of limited liability, which I have mentioned a little bit before my colleague also came, limited liability facilitates investment. It makes a whole lot of us members of companies, even when we are so distant from that company. So because we trust the management, the directors, to do right by us, it is just okay for us to, maybe if we have some money, maybe 500K, we invest some, 1 million, and a lot more people invested this way. A lot more. So for that to continue to happen, those that are in charge of those assets, those monies, those resources must come under a duty they cannot change, to be responsible, because they are agents. And every agent has a propensity to steal. So directors are agents, and they are agents of people, of persons that is not physical. It's even worse. Because companies are juristic persons, they're not natural. So the more reason why those that control its operations, keep its assets, its properties, its monies, must have a set of duties that they cannot change on their own. Otherwise, it will be an open check for them to steal everything. But if there are rules that can bring them back to reckoning, to accountability, then we are trusting that they will have some fear in themselves to do right by the company. So those set of rules are usually mandatory. So you can see now that company legislation amalgamates the protection of private interest, the facilitation of private interaction and negotiation, and also the protection of public interest. So in a way, it has its own public interest component. In another way, it has, the private interest component. The negotiation that is expected to happen among private people joining companies is what the model articles exemplifies. The model articles is the arena where members of companies can negotiate their deal and put it in the articles. and put it in the articles. Because it's in the articles, because the articles, if you look at section 32, 34, the articles are regulations, that regulates the stakeholders of the company, members in particular, what the company should do, what the members can do, the rights they have, and all of those things. They are in the articles. And the articles are default provisions. That is why when you go to section 34, you see a hint. We see a hint of the default nature of articles. Okay? And I want you to quickly go to section 34. Yes. Default application of modded articles, you can see. The default nature is that when we get to defining, because I want to explain these provision types to you very well. I don't want to assume that you all know, because some of your members refuse to forget what they learned when you're in year 3. And I really thank them, because it makes me very happy, really happy that we still have people who can remember this kind of stuff. Yeah, this knowledge is a continuum. When we're teaching you then, it may be fun. I don't know whether it was fun for you, but I know people will squeeze their eyes. But it's because of today that we are learning, we are teaching you that, because I know you are going to come across it in a much bigger way. If you look at sale of goods act, it's a very small legislation compared to CAMA. So being able to apply that knowledge to CAMA, to unravel it, to access it, to understand it, to operationalize it, depends on you knowing the structure of CAMA. Being able to deploy it to advise clients depends on your knowledge of CAMA and how they are to be applied. Otherwise, there's no way you can advise clients properly, because your advice has to be around the provisions you have in it and then how you apply them. So that is why it's very, very important, one, to understand the fact that company legislation CAMA touches both public and private interests. But the way they manifest differ. The way they manifest differ. As your colleague has said, those 3 provision types you expect to find in CAMA are, mandatory provision, enabling provision, and default provisions. For reasons, mandatory provisions, as I explained, are provisions that compel those who operate the companies to obey those rules, because by and large they are they are designed to protect the public. And who are the public? When companies fail, when a whole lot of companies in the in society fail, like Enron. I don't know whether you remember Enron, but even if you don't remember Enron, because Enron failure came to fore in 2001. I don't know where you are in 2001. Maybe you can guess where you are to know whether you could even have known about Enron. But for those of us who are well advanced in age, you will know about Enron Corporation in the US. And when it failed, it has a very large international effect, to a point that the federal government, that is the United States of America, had to intervene to enact what we call the Sarbanes-Oxley Act of 2002. And all that regulation did was to regulate the internal affairs of companies. They never used to do so, but they had to, because public interest was seriously dented, affected, and it could make a lot of people lose interest in the capital market, because the shares of Enron were tradable at the capital market. Closer home, you remember during when Sanusi was the CBN governor, 2009 or so, those companies, those banks that were mismanaged, that they confiscated or withdrawn their licenses. Oceanic Bank, I remember. Can you help me out with those banks? You know, Oceanic Bank was one, Intercontinental was one. Yes, what are the rest? Hello?
I think Skybank.
Huh?
Skybank.
Sky what? Skybank.
Hello, sir. Afribank,
Yes,
sir.
Afribank. Yes, Skybank interest. Yes, was recent again. So, but it
Afribank,
wasn't.
sir.
Yes, thank you. Now, and there's another one that another company acquired. Was Heritage or whatever. Right? Now,
Diamond
what you
Bank.
need to do is to go back to the World Wide Web and then Google, the failure of, the withdrawal of banking licenses by CBN 2009. They will come. If you look at what they did, if the report comes, you will see what happened. There is this person, Peter. You need to block, please. You need to block
sorry.
So if you look at that report, you can Google that. Once I talk about Sanusi, you know the time, 2009. You just go online and bring up the report and read about it. You just need a hint, and you have the template the instrument through which you can search for the right information, and you read it. But you are going to now mix it with what I'm teaching here, that there is a need to protect public interest through karma. And those are manifested in provisions. It has happened international wide. It has happened in Nigeria. So it's much easier for us to understand why those things are there. When you talk about auditors, the role of auditors, their limitations, their liabilities, they are all prescribed in karma. So, and there are so many filings you must file because you must keep, and because the government, the company must keep filing returns for the public to have information about what you are doing, to decide whether your company is a company to invest in, to see whether you are doing well, you are transparent, and all of the problems you are having will be online so that people can learn. So to that extent, so you have the mandatory components of company law or company legislation. The facilitating part, or the enabling part, or the empowering, because I talk about empowerment and enablement, they are the ones that allows companies certain, opportunity to dabble into one thing or the other, because they need to have that enablement or that empowerment to be flexible in business. When you are in business, they say, there must be options for you. So that enablement or empowerment is also very important to help, the participants in that industry, which are companies, to really grow, their base, to improve on their investments and stuff like that. Again, how do you identify these provisions? I want to believe that there are some keywords you will use then when a provision mandates you. You say shall, rarely we usually must. Sometimes the language or the phraseology is such that you have to obey it. You don't have a choice. But shall is always, a language of recourse to indicate compulsory compliance. Okay. Then also, when a provision enables, the word may also comes in. The word may also comes in, and there are so many of these, this shall or may that you find in karma. And of course, the default provisions is the one that provides an underlying rule. That underlying rules is the one that you are empowered to change to your taste. But if you fail to change it, the rule that is originally given to you becomes a mandatory rule to you. So that is how we define, default provision. Every default provision has three components: the original underlying rules, the enablement to change that rule through a particular medium, and of course, failure to do so, you have the rule becoming a mandatory for you that has failed, not for everybody. For those who are smart enough to know, then they can change it, and of course, apply it, domesticate it as they want. So that is how these things work. So, and usually my approach to this is that if you know these three types and the words to look for to get it, then you are good to go. Go to CAMA and compile 20 provisions that are enabling, 20 provisions that are mandatory, 20 that are default. There are so many. I can give you section 87. If you are dwelling around section 87, you will see a whole lot of default provisions there. And even the ones I've asked you to read from 18 to 30 something, 37, go back on them and see how many of them you can really classify as mandatory, as enabling, as default. Then when next I come, instead of doing another lecture, I just want to listen to you, your own 20, you've compiled. We are meeting again on Thursday. I don't want to go beyond Thursday over this, because there are still a lot of issues for us to raise. But this template, this where you are now, is what we need to transit, to the other aspects of it. And it is also what you need to make CAMA or company law much more friendly to you, and much more, then you can see the rewarding aspect of it. So I think we've done enough today. It's 2:03. So our time is spent. I'm sure you have other lectures. It's been wonderful to share my own knowledge, with you today. And hopefully, by God's grace, we'll see you on Thursday.
Hello, sir.
Have a very wonderful day. Bye.
Hello, sir.
Hello, yes.
Yes, I have a question, sir. This
you will keep it till Thursday. Okay, time is
in
gone.
terms of your teaching materials, how can we access it and get it personally so that we can probably read on it? So that's that, sir.
Okay. You will see on Thursday.